A very good afternoon, ladies and gentlemen. Thank you for tuning in. Hope you are having a pleasant day. With that, I would like to welcome everyone to the Real Talk webinar brought to you by the Excel Academy of Real Estate. Whether you're a seasoned pro or just dipping your toes into the world of real estate, the Real Talk webinar is your golden ticket to learn from industry experts who have navigated the ever changing real estate landscape, gain access to their insider knowledge, and stay ahead of the curve with up to date market trends. In this episode, we have the honor of welcoming Mr. Mark Goh, a non practicing advocate and solicitor of the High Court of Malaya, to speak on the topic of an estate agent's guide to understanding offer letters, key elements to consider. If you have any questions for Mr. Mark, feel free to leave them in the Facebook comment section below, which we'll address at the end of the show. Without further ado, join me at welcoming Mr. Mark. Welcome, sir.
Thank you. Thank you for the kind introduction. So today we'll be looking at discussing the first topic, an estate agent's guide to understanding offer letters, key elements to consider. This is my qualification as well as my professional position. And I also do a bit of quite a number of publications, right? These are some of my publications that I have done. Okay, at the Malaysian Inside Malaysian 𝐤𝐞𝐤𝐬, you can actually look at it, some of the publications that I've done. Okay, now let's dive into it. Let's dive into this topic entitled letter of offer or letter of intent. Now, the outline of this presentation, this is how it goes. The first part, we will look at the importance of a letter of offer in a sale and purchase transaction. The letter of offer is a precondition, usually. It's an initial step before signing the sale and purchase. So I want to focus on this this initial step first. The next one we'll be looking at will be the key terms in the letter of offer. What are the key terms that are found in the letter of offer? Usually we'll just ask people, usually estate agents will say that letter of offer is a standard, you have to sign standard letter of offer. The terms are standard. Well, let me tell you, there's no such thing as a standard letter of offer. There's no such thing as a key, or there's no such thing as a standard terms. But having said that, there are some important terms that has to be inside a letter of offer or letter of intent. And finally, we will address the issue: is the letter of offer, is it enforceable in the court? Is it actually an offer? What is it actually? So let's look at the first part, and finally I will take the Q&A questions. Now let's look at the first part. Letter of offer, what is it? It states here that it's a preliminary understanding of the parties who intend to enter into a contract in the near future. Meaning to say that after the preliminary negotiation, after discussing some of the main terms, the parties may want to enter into a contract. So this is a step before entering into a contract. You dip your feet in before the next stage. So it also states that it forms the framework for the sale and purchase. Okay, it is the foundation where the terms are incorporated into the sale and purchase agreement. So it's a step before that. So the sale and purchase agreement will list out all the terms and in details, but these are the pre-initial main terms, or the initial main terms that the parties would have to agree before they move on to design a proper sale and purchase agreement. Now, the next thing is this. It serves as an initial offer. It is drafted based on preliminary information that is provided by the seller or the selling broker and on initial due diligence. So what you have here is actually very basic information, basic limited information that you have here. Name, the identity, sometimes the actual title, so you don't have, right? what is inside the title also you don't have. You need to do a title search first, but you need to sign on first before. So you give basically what you have is an initial offer, right? So it sets forth the material terms of the proposed deal and is designed to confirm that the deal really has been reached and all the parties are on the same page. So it sets forth the material terms. What are the key terms? Who is the name of the buyer? Who is going to buy? Who is going to sell? At how much the property is? How much they need to pay upfront first? Where is the property? And so on and so forth. Okay, these are some of the key terms, key material terms, right? You need to seal it first, or else, like I said, it's just only negotiation. Another important step is it serves as a precursor, first step to a more formal, legally binding agreement between both the buyer as well as the seller. So it's a first step rather than just talking. Both parties are actually signing on to at least some, putting their agreement into paper. I would say putting their agreement into paper, but it's before the contract. Next, it allows the parties, with the next important of the letter of offer, letter intent is it allows the parties to agree to the critical or the main terms before finalizing the contract. This is important because it ensures that both parties are on the same page. Now, if you can't even agree on the main terms, then don't bother signing the contract. So, for example, you can't even agree on the price of the property. You can't even agree on how the property looks like. You look at it, you don't want to even buy. Then what is the point of proceeding on? Can't even agree on the price. What's the point of going on? If one of the parties, having looked at it, decided doesn't want to sell you, there is no offer, he pulls it back. What is the point of going on? So at least with the lotto offer, it is a first step. It is a gauge. It's like a temperature gauge to see whether they have agreed, whether the main terms are agreed. Okay. Next, it defines the expectation of the parties, particularly the timeline, the purchase price. These are the main ones. Timeline, purchase price. I'll tell you about the main ones. What are the main ones? Which we usually take for granted. Okay, how are we going to finish this? Is it 3 months? Is it 9 months? Depending if it's a leasehold, then it's 9 months. Get the approval first. If it's clean title, usually, not all the time. Usually, clean title don't have subject to approval of the state consent. No state consent is usually 3 months. So agree to a proposed timeline doesn't mean that it's always 3 months. Okay, usually it's 3 months, but the parties may want to agree to some other timeline, that depending on the parties. So, but at least the letter of offer gives you some certainty as to the key terms. Okay. Next, it indicates to the seller, yes, this is important, of the buyer's commitment to the transaction. The letter of offer shows that the buyer is committed to the transaction. He's serious. Okay? So it basically tells you psychologically, this is not cheap talk. I look at a property. I want to buy. I'm interested in buying. Right? It indicates to the seller, oh, this guy is actually interested in buying. This is the importance of the letter of offer, because he's willing to put his signature down on the letter of offer. Right? Right? He's willing to put his signature down. He's talking, others say, I am not interested. Let me think about it. Some of them will say, let me think about it. So psychologically, it's like, this guy is not interested. Right? But if the buyer puts his signature on the letter of offer, it is an indication to the seller, and the seller knows, I'm about to close the deal. I use the word about. At least 60% is settled. I'm talking about closing it. right? Agent also happy lah, no need to say. Next, it also helps the buyer to feel more confident in the ability to complete the transaction. So when the buyer, this is also good for the buyer if you look at it from the perspective of the buyer. Okay, the buyer, when he signs it, he also knows, okay, I am getting this property. He's more confident that the seller will not pull it back, right? That the seller talk will not say, today I sell you, tomorrow I can sell to somebody else. If it's not, if the document, no documents are signed, the buyer will also be worried. Okay lah, right? I agree to buy already. Then the seller may turn back. Okay, tomorrow may not sell the property to me. The buyer also don't feel so confident. But if you sign the letter of offer, it gives confidence to both the buyer as well as the seller. It's kind of like seals up not completely, but at least it seals up that transaction. It gives confidence to both parties before moving on to an official sale and purchase. Okay? Right? And it allows both parties to move forward. Meaning to say what? With due diligence and the negotiation of a more detailed sale contract. So this one, objectively, at least the party can move forward now. We are done with the first stage, which means, yes, he has already shown the interest. Yes, he's willing to buy. Yes, this guy is willing to sell. Okay, no more indecision, no more, I mean, there can be negotiation, but then no more all this preliminary negotiation, no more look-see. At least we can move forward. The next step is we can now appoint a lawyer, sign the contract. No more discussing, how does your house look? Where is it? So you want to buy, you don't want to buy. No more all of this. We're moving on to the next step. Okay, moving on. So it's an indication. Signing the letter of offer indicates that parties are advancing. It's a good indication. It's a positive indication. Okay. Right. Now, next we will look at is the key terms. What are the key terms that are found in the letter of offer? What are the key terms? Now, first thing to take note is it is not a standardized document. The letter of offer, although most of them say standard one, the terms are standard one, right? It is not a standardized document. So you need to ensure that your rights are protected. And it's important to make sure that the letter is drafted correctly. People say it's standardized because they have already drafted it and all that. We don't want to change. But please take note, it is not a standardized document. You need to fit it to the facts of the case. So what does a good letter of offer? Does a good letter of offer protects all the parties in the agreement. Okay, it protects all the parties in the agreement. Now, what should a letter of offer have? What are the key terms? It should include the important details such as the name of the seller, the name of the buyer. It's a no-brainer, but I still put it in. Okay, something like a checklist for you to look at. Name of the seller, name of the buyer, address of the property. Yeah, the legal address of the property. You may not have the full title yet. Correct? At the point of time, the person may not have given you the title. You may not know what is inside the title yet. But at least the address is there. Okay, the address of the property. Price agreed upon for the purchase. So the seller will not turn back and say something else. The buyer will not turn back and say something else. Right? The price that is agreed on. At least the price is fixed. You have actually fixed on the price. If not, it's floating in the air. Once you have a letter of offer, it's fixed. Okay. The total earnest deposit to be agreed. How much to pay? Usually is 2%, right? Right? It's usually 2%. And the payment also indicates that this guy is serious. See, all the psychological aspect, okay, the physical payment, right, issuing of the check, signing, also shows that this guy is serious, the buyer is serious, that the seller is serious. Okay, the date in which the sale and purchase must be signed. There must be a date. Usually it's 7 days, correct? 7 working days. Some say 7 working days, some 5, some 7. But at least you move on. Okay, you close this stage, move on to the next stage. So there's a fixed period. Everybody, there's certainty for everybody. People are happy, we're happy, we move on, right? The date for the sale and purchase must be signed. And the terms and conditions surrounding the 2 to 3% earnest deposit. Okay, when should it be returned back? Can it be returned back? What are the circumstances it can be returned back? I'll deal with all of that later. Okay, sometimes you may want to put a note on any fittings or furnitures to be included. Not all the time, but depending on the parties, depending on the transaction, you may want, because some of them may want to buy because of a specific fitting, because of a specific furniture, they want to buy this property because of that. Some no. If it's not applicable, leave it. If it's applicable, put it there. But the point here is that at least the key points are stated down, right? They are stated down. Okay, next. These are the key terms. Now let's look at the key terms. Some of the key terms and what are their significance of these key terms. The first key term, or the first term that we have, or important term, which you always see, is this thing called as is where is. It's always sold on the as is where is basis. It's as is where is basis. As is where is. As is where is means what? What do you mean when you say it's as is where is? As is where is means what? Everybody say as is where is. As is where is means what? Well, there are some cases I've given to you. It says here, the Court of Appeal, I think, says that where a person buys land on an as is where is basis, this is a legal significance of the term as is where is. He takes the land with its existing conditions as at the date of the sale and purchase agreement. And there is no implied warranty or representation by the vendor. Right? The buyer is deemed to have checked the property for defects of quality and have found the property acceptable. So it's as, it means what it is. It is as is where is. So the buyer, on the other hand, if the condition looks bad, the buyer cannot say, hey, you say like that. No, it's as is where is. Flip it the other side. The buyer has to be caveat, what we call it as caveat emptor. Let the buyer beware. Before you buy something, you better do due diligence. You better check. You don't do due diligence, you don't check, you buy, that's your business. Caveat emptor, right? Let the buyer beware. The seller is not going to tell you everything. It's for you to ask the right questions, for you to check the thing properly. If you don't check, then that's it. It's what we mean by as is where is. Okay? So the burden goes on to the buyer. Now, having said that, it will not apply if the seller has made a representation and the buyer relies on it. That's where some of the problem comes. Okay, the case is made at the AIM edition and against mBank Court of Appeal. As is where is principle does not apply, wherein because there is nothing to show that the size of the said land is other than what was proclaimed in the proclamation of sale. So that is specifically what AIM edition is saying. So if you make a representation, right, and the buyer relies on it, then that representation negates, or what we call cuts out, the as is where is basis. Right. Now, the statement here is talking about a proclamation of sale, because in AIM edition, what happened was, the fact was that they were selling, the property was on auction. So because the property is on auction, so the description of the property is stated in the proclamation of sale. Okay. The proclamation of sale actually described how the property is. What the proclamation of sale should have done was that said that this property is sold on an as is where is basis. But I don't know why this proclamation wasn't stated like that. They actually describe the property. So when you describe the property and you say this property has this, has that, it automatically will negate your as is where is, right? Because the buyer is going to say, you told me it's like that, right? You told me it's like this, you told me, I therefore rely on you, and he can sue you for misrepresentation or not. Okay, so the moral of the story is, don't open your mouth too much. Sometimes if you need to keep quiet, just keep quiet. Open too much, you tire yourself out. Okay, right? So that's the significance, the legal significance of an as is where is. Next, signing deadline of the SPA. Yeah, things to consider. Signing deadline. Now, the time frame to sign the SPA or SNP should be carefully considered and tailored for both parties, right? Depending on their respective circumstances. For example, the parties may be overseas, stuck in outstation due to unexpected lockdowns, COVID, require additional time beyond the typical 14, 21, some 7 days only, and some 14, some 21. So depending on the party, so you need to negotiate, right? Some will say within 14 days, 21 days, or any further day as any other time as may be agreed by the parties. Right now, with the lockdown and all that, you don't know, right? But generally, got 7, 14, 21. Some will put their working days, right? What's the difference between 14 days and 14 working days? You don't count, if it is a working day, then you don't calculate the weekends. If it's 14 days, you calculate the weekend as well, with the exception of, yeah, right? With the exception of Sunday. If not, it's working days. If your office isn't open, then it's not a working day. So that's the difference, right? So general rule, if the intended purchaser fails to execute the sale and purchase within the duration, the earner's deposit can be forfeited by the vendor, or if the vendor fails to execute the S&P within the agreed duration, then he must return the earner's deposit to the purchaser free of interest. Right? That's the significance of the deadline to sign the S&P, because whatever is negotiated in the letter of offer will be crystallized in the sale and purchase later. Right? The key terms will be crystallized, will be transferred to the sale and purchase, and will be crystallized. It becomes a term already, or the sale and purchase. Right? So you need to discuss the agreement. Like I said, sometimes the parties may say, I cannot sign within 21 days. I can't sign within 14 days because I'm away or whatever, overseas. Or then consider that, right? Don't just simply sign, consider. Okay. Other factors that could legitimately require a longer signing time frame would include waiting for loan approval, checking with EPF on the amount of withdrawal, blah, 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 blah. But usually 14, 21 days should be enough. But like I said, specific cases may require specific timeline. Doesn't mean 14 and 21 is cast in stone. You must follow one, cannot change. Parties want to change, go ahead, let them change. Okay, right? Leasehold property. Okay, things to consider. The remaining years left on the property. If the property is of leasehold, I use the word leasehold, I know, okay. I don't want to be very technical over this. Leasehold, you know what is leasehold, I know what is leasehold. So if the property is leasehold, check on the remaining number of years left on the lease term. The number of remaining years on the lease will affect the value of the property, right? While you can renew the lease by submitting your application to their office by paying a premium, it will cost you time and money. Banks are often, if your lease is less than 50 years, very hard to get loan. Okay, almost impossible. If it's down to 30 years, it's almost impossible. So check, this property I'm going to buy, is it leasehold or not? Is it freehold? If it's leasehold, I mean, how many years left? Just ask and see. So you can put it in the letter of offer, right? If they say cannot give it to you, say, okay, if it's, put it as a term, right? If it's less than 30 years, then, or less than 50, then the offer is subjected to the remaining years left. This offer is subjected to the remaining years left, or the acceptance is subjected to the actually not acceptance, this offer is subjected to the remaining years left. Anything less than that cannot be offered. Okay, right? Okay, next. Tenancy, yeah. So you just need to state, okay, things to consider. Not every time you put it. If the house is tenanted, you may want to put in a term. A clear specification should be made as to whether the delivery of vacant possession will be with or without tenancy. If there's a tenancy, it will be beneficial as the buyer to review and assess the terms of the signed tenancy with the focus as to whether you want to renew the tenancy, don't want to renew a tenancy. These are issues to take to consider also, right? We are practical issues, people, correct? They are practical issues, right? Is your house tenanted or not? So if your house is tenanted, so you want to put it in, you want to take the tenant or you don't want to take the tenant, right? Right? Some may say yes. No, you may want to put that in. I want to buy without the tenant, so if not, right? So you may want to put a condition of tenancy in. Co-owners, another issue. Okay, the seller that sells you, okay, is the property owned by more than one? Did the other person agree to it? You're dealing with one person, the other person agree to it. Okay, so it's only signed by one co-owner. Is there a possibility that another co-owner may not be agreeable? So you may want to put a condition. Agreeable if, okay, this offer may not be valid if the other co-owner doesn't agree to it. Okay, you may want to consider that, right? Some things to think about. It's a kind of a checklist that I'm giving to you. Co-owner or not, did he agree or not? All those usually don't have. You won't know one. You really wouldn't know. You need to check, and you don't have time to do the title search. I mean, we all don't do title search when we are doing preliminary negotiation and all that. Where do we do title search? So ask. If you can't do title search, ask. Okay. Okay, next. Option to purchase. Yeah, this is another one. Okay. Option to purchase. It is a unilateral contract offered by the offerer to the offeree to sell him the land subject to the offeree complying with certain specific conditions and the method of exercising the option. In order for an option to purchase to turn into a binding contract, the offer must be accepted and exact compliance with the terms. The acceptance must correspond with the offer. Once the terms are complied, then the option will buy the grantor. Sometimes there's option to purchase one. I give A an option to purchase. Okay, A will say, okay, hold on. Can you give me an option to purchase or not for 5 days? Let me think about it first. Okay, I give you the option to purchase. So in the meantime, I cannot sell it to other people. But when I give you the option to purchase, you also must follow my conditions. If I leave this option to you, I keep the window open for you to buy, but you must follow my conditions. If you don't follow my conditions, I can offer it to somebody else. Right? Option to purchase is another key point that you need to consider. Then after that, you have at the bottom there other conditions. Right? Other conditions. Okay, let me just open this. So for other conditions, word your conditions so that the buyer's 2% may be returned if the valuation comes out. Now, these are other conditions. Sometimes you may want to value the property first. If the valuation comes out lower than the purchase price, or the buyer is unable to obtain the home loan, or either party cannot come to an agreement to any clause. So now this is not standard one. Sometimes they don't put it in one. Right? Sometimes it's not in. So other conditions, you may say, I want my 2% back if I cannot get a loan. They didn't approve my loan. Or both parties cannot come to an agreement. This to the sale and purchase. And this is quite common. Both parties cannot come to an agreement for the sale and purchase. The problem will arise if this is not in the condition and then the 2% is paid. You know why it will arise a problem? Because the agent is going to say, I already married the parties already. Okay, I already married the parties. I'm entitled to my what do you call that? Commission. But then the parties may agree initially, but later they didn't agree. Right? So it's best to clarify all this, put it in the other conditions. Usually it's not in one, but it's for you to look at it. Okay, I'm able to come to an agreement in any clause in the sale and purchase. Okay, sometimes the letter of offer is subject to financing, correct? I can't get financing. So if I can't get financing, then I don't want to buy. right? If it's not stated there, the guy is going to turn back and tell you, you already signed, it's not a term of the contract. Sorry, it's not a term of the letter of offer. You already agreed to buy, you're going to find money. That's the other problem. Okay, it's not to say you cannot get back. It will be more problematic because it's not inside the letter of offer. If it's inside, then you can point straight away. You see, we didn't come to an agreement. I already said subject to financing, I can't get financing. Okay. And then lastly, sometimes the purchaser may wish to purchase the property because of a particular furniture. Okay, I want to buy because of a particular furniture. So to avoid any doubt, you will say this, the letter of offer, the term says he will buy subject to these conditions. The condition is I want to buy with this article in as well. Right? If this article is not in there, I don't want to buy. Okay, you may specify it up to you lah. Okay, not to say up to you, up to the parties. Again, I'm providing different scenarios. Okay, usually it doesn't happen but sometimes they may purchase it because of a particular furniture. Then that has to go in. I'm buying it subject to this condition. The first one is, okay, that this furniture must be so on so forth. Right? Okay, now let's look at the last part. Letter of offer. Is it enforceable? So once you sign the letter of offer is already signed. Is the letter of offer then enforceable? Right? Is the answer yes? Is the answer no? Well, the answer is it depends. It's not yes, it's not no, but the letter of offer, whether it's enforceable, it would depend. Now we are talking about the period between signing the letter of offer and the signing of the sale and purchase agreement. Okay, we're talking about that, right? I'm not talking about letter of offer flows into signing of the sale and purchase. If the letter of offer flows into the signing of the sale and purchase, once you sign the sale and purchase, it's a done deal already. Don't bother with the letter of offer because all the terms of the letter of offer would be incorporated in the sale and purchase. So you look at the sale and purchase only, generally speaking. That is, if the terms say that whatever is in conflict, the sale and purchase prevails, then no issue. What we are talking about is the period when you sign the letter of offer and the period you sign the sale and purchase. You may not sign the sale and purchase at all, or you may sign, or something may happen there. Something may happen. The guy may refuse to buy, the other guy may refuse to sell. Okay? Then what happens? Now, so we need to address this issue. The letter of offer, is it enforceable? Well, it says a party signing a letter of offer may, now the keyword is may, it doesn't say must, may be legally bound to honor it, depending on how the letter is drafted. So which means it may be enforceable, it may not be enforceable. There's no one size fit all. So how do you know it is enforceable or not enforceable? We need to look at cases. Now, usually there's this term called subject to contract. Usually when people are negotiating, especially in the letter of offer, there is this term called subject to contract. What's the significance of this? Now, this federal court case of 𝐒𝐤𝐷𝐸 says that the Supreme Court then says that when an arrangement is made subject to contract, it will generally be construed to mean that the parties are still in negotiation and they do not intend to be bound unless the formal contract has been executed by the parties. So this federal court case say that, or Supreme Court case say that, if you have the term subject to contract, if your document has, or your letter of offer has the term subject to contract, then this letter of offer is not a contract. It is still negotiation until both parties sign the agreement. So this means that if the terms are not followed, it is still okay. That would be the effect of this case. That would be the impact of this case, right? If which means it would imply that after signing, I decided not to buy. Okay, I return the money back to you, blah blah blah. Or you decided not to sell, everything go back to original position. That would be what this case implies, lah. Provided your letter of offer has a subject to contract. If you don't, then we have a problem. Now, on the other hand, you have another federal court case. This federal court case says that otherwise, it says, federal court in this case has decided otherwise, given that the parties in the sale and purchase transaction have been identified sufficiently so to have the property, the price, the essential terms. Hence, even though there is a subject to contract term, there is a concluded contract. This is another view. That's why I say it depends. So even though there's a subject to contract, the federal court cases in 𝐒𝐨𝐲𝐬𝐜 say that, hey, even though you have a subject to contract, this sale and purchase transaction was inked. It was basically inked. Another word is, it was enforceable from the time the letter of offer was signed. It was enforceable. Why? Because the parties have agreed to sign the sale and purchase. Okay, in the letter of offer, the deadline for the sale and purchase has been fixed. See, the sale and purchase transaction has been identified. The parties have been identified. The deadline has been identified. The property has been identified. The price has been identified. All this has been identified. So the key elements of the subject matter of the contract. I know what I want to buy. You know what you want to sell. I know at how much. I know when you're supposed to give it to me, and so on and so forth. So the key elements have been made. So even though once the key elements have been made out, you can put the word subject to contract. It is not going to work. It will still be a contract, right? That leads to the next question. So how? One case say this, the other case say that. Now how? Both are federal court decisions. How to solve? Okay. We got a third case. So what's the conclusion? Third case. Yep. View 1 and view 2. So how to conclude? How? What's the conclusion? Now the conclusion is a practical one. This is given in Deutsche Bank against MPF Holdings, a federal court case says. It says, number one, the parties have agreed to the terms of their bargain in totality. So that's the first stage you ask yourself. Have the parties agreed to the terms of their bargain in totality and intend to immediately be bound by them, and at the same time propose to have the terms restated in the agreement? I'll explain this later. Number two, have the parties completely agreed to the terms of the bargain and intended no departure thereon, and have made performance of the terms subject to the execution of the formal contract? And number three, have the parties' intention is not to make a concluded bargain at all unless a formal contract is executed. So there are three parts, three questions you have to ask yourself. Now, in the first two cases, there is a binding contract between the parties. Right, first two. The parties have agreed to the terms in totality and they want to be bound by them. All they need to do is they want to wait for the sale and purchase to be signed only. Other than that, they are agreeable. Number two, second situation, they have agreed to the terms, right? Waiting for the formal contract only. How do I know? You look at the conduct, right? So the deciding factor is this. So it says the first two cases, there is a binding contract, which means the contract came into existence when they signed the letter of offer. The sale and purchase is just a process for them to complete it. The deciding factor is this. Does the correspondent indicate that the parties to the agreement intend to bind each other? Now, what do you mean by this? What they are saying is this. What they're saying is this: looking at the so what you need to do is you need to look at the letter of offer itself, look at the terms in the letter of offer, look at the conduct of the parties, paying of the money, receiving the money, fixing. What looking at the terms and the conduct of the parties, did they intend to seal the deal when they signed the letter of offer? I'm not even talking about S&P. Did they intend to seal the deal already? Is the deal already sealed? The key terms are already done and dusted, sealed when they sign the letter of offer. Signing the sale and purchase is just a procedural aspect. If the parties have intended to seal the deal at the earlier part, then the letter of offer is a contract itself. Signing the sale is just a formality. But if the parties do not do not intend to seal until a contract is executed, then there is no contract. Now, I know what to do, how to do. Best practice. So what's the best practice? Because it's not a one size fit all. Because the court can say, oh, this letter of offer amounts to a contract. Oh, this letter of offer doesn't amount to a contract. It depends on the facts of the case. So what's the best practice now? What's the best practice? How do you prove? Hold on. How are you going to prove that you want to fall within the third category? The intention is not to make a concluded bargain. We don't intend. We just want to negotiate only until the contract is executed. So what's the best practice? The best practice here is to ensure that no premature binding contract is concluded through negotiations or exchange. I didn't suggest this. Suggestions by Deutsche Bank, the case of Deutsche Bank. It says that all negotiation and exchange are subject to contract and that the parties are not bound until the execution and exchange of a formal contract has been drafted. So what Deutsche Bank is saying is that if you want to express and you want to be clear that this is just negotiation, then in all your negotiation and exchange, state that this negotiation is subject to contract. Now, if you want to be really safe and really kiasu want to be safe, then you say all these negotiations are subject to contract, are subject to a formal contract being drafted. Here. Wait. All negotiations are subject to a formal contract being drafted. This part here, there. Intention is not so. You're going to say that this negotiation or this letter of offer is subject to a formal contract being executed. This negotiation is being subject to a formal contract being executed. That is really clear already, rather than just saying that this letter of offer is subject to contract, because that one itself is also not clear, because that one you got the case to say subject to contract, let's look at the conduct of the parties. Right? If you really want, put everything like what Deutsche Bank say, subject to a formal written contract, subject to a formal contract, subject to a formal contract. Then that will be safe. Okay, again, depends on who you're representing. But you need to have this in mind already when you're drafting or when you're signing the letter of offer. Okay, you need to have this in mind. Who you want to tie up or don't want to tie up, or still want some leeway to negotiate. Okay, right? Okay, so I'm open to Q&A now. Thank you everybody for this talk and for paying attention. Thank you.
All right. Thank you, Mr. Mark, for that comprehensive guide. Now we'll move on to the Q&A section where you'll hopefully answer their questions. So for the first question, we have a question by Ms. Mizadi. What are some best practices for real estate agents when it comes to documenting and keeping records of offer letters and negotiations?
Oh, okay. When it comes to documentation, again, Nisa, it depends on. Okay, you're talking about one case, or you're talking about all the cases and you're keeping it. General rule, right, would be, of course, to keep them all. Open up a file, keep them all, right? In a file. Now, the safer one. I mean, the safer one would be you put all under, in terms of negotiation, you put all under subject to contract. Okay, I will put the word subject to contract. Okay, you don't need to put all your documents all as subject to contract, but most of it you need to put. Some you will say subject to contract to a formal written contract. You don't need to put all the contracts, all the agreements in that phraseology, but one or two will do, because all of it is a collection. So you can have entire collection to determine the intention of the parties, because the courts will look at the entire collection of the documents, the series, to decide whether it is a negotiation or it is a real offer. Right? Okay.
All right, thank you, sir.
Again, depending on who you represent, you see how the thing flows, lah. What I'm saying is that how it flows, as in, you want to seal the deal or you don't want to seal the deal. Are you with me? Right? I cannot say, oh, everything must subject to contract. Sometimes, if you're representing a party and later he says, actually, your client may tell you, actually, I'm not sure whether I want to sell my property or not, but I want to see how it goes, lah. Let's say your client tells you like that. I want to see how it goes, but I'm not sure. You could have or your client will tell you, this one owned by two owners and all that, but we got some issues, but then it looks like they're agreeable to it. Then you know, if you're agreeable to it, but then got issues, you may want to put subject to contract, subject to a formal contract, right? But on the other hand, if your client says, I want to buy this property, right? You may have some idea, oh, you're the buyer, then you may not want to put subject to contract, correct? You may not want to put, correct? Because you want to seal the deal, right? You want to seal the deal, then you don't want to put on. So this subject to contract is, it depends on who you represent, to put in, okay? Okay, next.
All right, next up is a question by Miss Nazliana Nazaruddin. What should real estate agents advise their clients regarding the acceptance or rejection of offer letters?
Okay, I'm okay. Again, it depends. It depends on how bad your client wants to buy that property, lah. Okay, it depends on how serious he wants to buy the property, right? Although I say there's no such thing as a standard contract, but I know in reality, all letter of offers have got main terms. The main terms are there already, right? So again, you need to ask your clients, right? The main terms are there, but the main one is, one of the things that are usually not there is that, from my experience, is that if the parties don't agree to the sale and purchase agreement, the terms of the sale and purchase, and it's usually not in one, so you need to have basically a way out for your client. Okay, in terms of what would you advise your clients regarding the acceptance or rejection? Have a how do you go? Have a open door, have a particular escape route for your client to go out, right? And which I already explained, one, the 2%, putting the terms. Okay, you need to look at the terms. Sometimes the so-called standard terms don't have that one, right? If they don't agree to the terms of the sale and purchase, if he cannot get his loan, then have that as a open escape clause for him to, escape term for him to run, or else he's going to be quite susah.
Mm-hmm.
Okay.
Okay, thank you, sir. Next, another question from Nur Atun. Are there any common mistakes or pitfalls that buyers should avoid when drafting or reviewing offer letters?
Okay, you're talking about buyers. So the thing is for the buyers, common mistake that buyers should avoid when drafting. So if you're looking in terms of the buyer, you want to seal the agreement. You want to try to seal the agreement. So you look at, they're not particular common mistake. So what you do is when you look at the agreement, look at the letter of offer, you will look at those terms that allows the buyer to actually seal up the deal. Things like within 14 days, within 21 days. You want to quickly get the S&P signed as fast as possible. So it's not really a common mistake, but this is what you should look out for, the buyer. When should you sign the sale and purchase? Can this guy get the loan or not? Right? Can he get the loan? So some of the things also you need to discuss is he able to get the loan? Right? Is he able to get the loan? If he can't get the loan and it takes too long to get the loan, also got a problem. You must have
Mhm.
go and sell it to somebody else. So sometimes what is good for the seller, if he wants to get out, may also be good for the buyer. You get my point? It's like
Yeah.
I already cannot marry you already. You can't really get the loan. I must well go and look for somebody else to sell lah. Why am I
Yeah,
get force myself get stuck with you? Then after that signing the sale and purchase, oh la la, give headache, man. Correct?
true.
Right. So
Mhm.
so so that's the answer to it lah.
All right. So basically, just be clear with one another on like your situation. Yeah.
Yes. Yeah.
All right. So I think that's all the questions we have for today. Once again, I would like to thank you for that talk you gave just now. It was very detailed and I would say very comprehensive with all the case studies and examples you gave.
Okay.
So yeah, thank you again, sir. With that, I would
Okay.
like
Thank you.
to invite all of you to the our next Conquer Sales and Marketing Summit. Sorry, let me just share you the screen. Right. So I would like to invite all of you to the Conquer Real Estate Sales and Marketing Summit, Strategies for Success in the Digital Age, happening on the 13th of December 2023 from 9:30 a.m. to 5 p.m. at the Armada Hotel Petaling Jaya. So for session one, we have Mr. Alexander on digital marketing. Or session two, we have Miss Gayatri for social media. And lastly, Mr. Taco Hedinga for sales. So if you are interested to join, please contact one of our sales rep, as well as visit our official Facebook page, which is Excel Academy of Real Estate, and also our website, which is realestate.excelacademy.my. Once again, thank you, Mr. Mark, as well as all of you guys for tuning in this fine evening. We hope to see you in the next one. Thank you.